Mount Carberry landfill expansion permit was pending, and panelists could not recall. I wanted to move to reopen the record under Rule WMC 205.11, simply to ask the council to take judicial notice that in fact there was an expansion permit proposal pending from the Mount Carberry landfill with DES at the time that DES was engaging in its capacity analysis. And I've shared information with both council.
Chair Roy?
I had no objection. I just want to make sure it's clear on the record we're maintaining any objections we had to that line of questioning, but the judicial notice issue is fine with us.
Okay, perfect. Chair Harrison?
I agree with counsel for NCES.
Very good, thank you. Okay, it is noticed. Thank you.
Thank you.
Chair Roy?
I have just a housekeeping matter for us as well. We have our response to the memorandum that CLF filed at the end of the day on Friday. Should be the original stuff, but if you count it, that's wrong.
Thank you.
Housekeeping matter to clear up with regards to the council's request for information that was shared with us
Go ahead.
just moments ago.
Actually, Council, I'm going to ask if you can step
Yep.
up just to make sure. Yes, you guys are so far away from the microphone. I want to make sure it's not the case.
And if you could remove your mic, your mask as well.
Good morning. So thank you for the request for information, and we will be addressing these in our closing point by point. But we objected to the phrasing, and I want to raise this with the hearing officer, of 1A and 2A. It states that DES made a determination that the short and long-term capacity need for the state was adequately measured. We object to that phrasing because there was no such determination by DES, and they had testified to that effect on Friday. And so that's in 1A and 2A. And then in 1B, it states that DES made a determination that there was sufficient capacity during the entire lifespan of the permit. We also object to that phrasing because DES did not make that determination that there was sufficient capacity during the entire lifespan. And that is in 1B and 2B. And that is also demonstrated in DES's analysis exhibit 8, CLF exhibit 8, and in their testimony on Friday.
Understood, Council. This is actually leading to another question that I was going to pose to the attorneys here, which is there was a request that a copy of these questions be distributed back out to the council prior to closing arguments. I was going to see if the council, or if the attorneys have any objection to that distribution. It sounds like because of this language issue, CLF would be objecting to a copy of these questions being in hand to each council member.
We are fine with them being in hand with striking the language that they determined with those two edits, basically, that I said, that they didn't make that determination in 1A and 2A, and that they didn't make that determination in 1B and 2B.
Understood. Please stand by.
understand Mr. Marco's position, that's fine, but, I don't have anything further to add in terms of the contents of this document.
Okay, thank you. Attorney Harrison?
Yeah, I agree with that objection to this. I think it's something that can be addressed in closing arguments. RSA 21014 makes it clear that the issues on appeal are those raised in the notice of appeal. As counsel for NCS stated, this is something that can be addressed in closing. This is an expression of the counsel's questions, but the issues on appeal are those within the appellant's notice of appeal, and debating about what the language should or should not include is now addressed in closing is something that can be addressed in closing. It's not proper for debate right now. I'm trying to tweak the language here.
Understood, counsel. And that was the intent of Attorney Marco, but just to give a general outline, just to make sure these topics were being properly addressed. We assume, counsel, we're going to the closing, but just want to make sure everyone's on the same page for it. So I appreciate you bringing up those issues, and you're free to address them in your closing argument to make very clear what CLF's position is.
Thank you.
And there's no objection. Oh, you can take your seat, counsel. Thank you. NCES.
Morning. Thank you all again for your time and joining us for this hearing and coming back for day 2. We appreciate all of your time as volunteers in this proceeding. So why are we here? Is it to find error in a permitting decision that was documented in an application review summary and a detailed response to public comments? To find legal error in a decision that was grounded in RSA 149M11, where the department unquestionably applied the same criteria it's used for decades to determine whether a facility will provide a public benefit? No. This case is not about the Stage 6 expansion of NCES's landfill or the department's meticulous actions in reviewing that application. This case is about CLF's effort to contest any expansion of landfill capacity in this state and to find error with any decision that contradicts that objective. CLF is utilizing the appeals process and this council's statutory authority to review permitting decisions to pursue an organizational objective. But luckily the law is not on its side because CLF has not met its burden of proof in this case. CLF doesn't get to determine what constitutes a substantial public benefit. That's not up to me, you, Mr. Marco, Mr. Durper, anyone else. The general court prescribed this public benefit criteria decades ago, and DES has been employing those factors ever since when it reviews applications for new solid waste capacity. In that regard, the issues before this council aren't new or novel because they arise from long-standing law. Instead, they are only new to the extent that they're being used as a tool to advance CLF's mission statement. You are all now very familiar with the public benefit criteria in RSA 149M11. And while the wording is dense, the objective is clear. And the department is tasked with ensuring that there's adequate capacity in this state to accommodate the waste generated in New Hampshire during that 20-year planning period that we've been talking about throughout the appeal. The department took you through each step of its analysis, explaining every decision, assumption, and investigation it conducted as part of that review of the application. Jamie Colby told you this is not a quick process. The review of applications is a long-term effort that involves several man-hours and dedication by the department. And you also heard the department tell you how seriously it takes its responsibility to review and issue permits. This is a responsibility that it alone bears in state government. No one else can do this job, and no one else has the expertise that DES brings to bear in the process. That's not in dispute either. Part of the department's dedication is reflected in the very existence of the application review summary, which is Exhibit 8 in your white binders. Nothing required DES to prepare that summary, but it nonetheless dedicated the time and energy to explaining every step of its permitting process to the public. And the same is true of the response to public comments in Exhibit 9, which aims to ensure that the public feels heard in the permitting process. Now, at the outset of this appeal, I gave you an overview of your standard of review, which I'm sure you're quite familiar with, but it bears repeating. Your job is not to determine whether you agree with DES's decision on this permit, and you're not asked to reconstruct its analysis and see if you would have arrived at a different decision. Instead, faced with the evidence that's stacked before you and all that you heard on Friday, was it reasonable and lawful for DES to issue the permit that it did when it made its decision in October of 2020? And the answer is a resounding yes. Was it lawful? Lawful under the council's rules means contrary to case law, statute, or rules. And I encourage you to keep that standard in mind as you're deliberating, because I saw one of your questions is about the lawfulness of each item on that list. So when you're asking yourself if it's lawful, you're asking, does this contradict the statute, the case law, or the rules? The testimony you heard is that there are no other rules governing public benefit. Public benefit is guided and governed by RSA 149 M11. And the record is very clear in this case that DES followed each step of that statute to the T. And that is documented in the testimony, it's documented in the application review summary, and it's documented throughout the record. The question on this appeal is whether DES measured the application against the standard prescribed by law, and there can be no doubt that it did just that. Was the decision reasonable? Now again, unreasonable means arbitrary and capricious. Now based on the testimony you've heard in this hearing, nothing could be farther from the truth in describing the care and attention that DES devoted to its analysis in this matter. Even Mr. Durfer concluded that the employees tasked with permitting are very conscientious and take their job seriously. The department's decisions are written out for your review in the application review summary, which details how each criterion was evaluated and how the department reached the decision that it did. The guesswork is gone. You can follow the analysis and see the reasonableness of it in black and white in front of you. So how did the department review the statutory criteria, and what decisions did it make? I'd like to help you just bring together everything that we've heard, because you had some time to think about it over the weekend while you were doing lovely things, I hope, in the warm weather. Because I want to bring it all together for you now in terms of what you should be doing with it as you're deliberating in this appeal. Capacity need. We've heard a lot of testimony about capacity need, and we've looked at crossover charts that talk about the need for waste disposal and the amount of capacity remaining, and how that's all going to be tracked over this 20-year time period. But you've also heard that this testimony about the steps DES has to take under the statute to determine whether there is capacity need for a new facility. So in answer to your question on whether it was lawful or reasonable to determine that that capacity need exists, the answer again is to look at the statute. There is no ability to go beyond that, because even Mr. Durfer testified that RSA 149.11.5 prescribes those 4 sets of instructions to determine capacity need. And need for capacity is not dictated by what CLF considers to be a need. The legislature eliminated subjectivity from the analysis with that 4-step process, and DES evaluated each of those steps in its analysis. It didn't accept the applicant's conclusions, and Ms. Colby explained how the department conducted its own calculations as to each of those instructions to reach the conclusion that it did. I also want to talk briefly about out-of-state waste, because we heard a lot of testimony about that and how out-of-state waste factors into this process. And it's important to remember what Mr. Wimsatt told you. Out-of-state waste does not factor into the process. While out-of-state waste may be a reality that's accepted at facilities across the state, the public benefit criteria in the statute that DES was limited to in reviewing this application, and that you're limited to in determining whether it acted lawfully, there is no room for analysis or consideration of out-of-state waste in that analysis. What could or should or might happen one day with out-of-state waste doesn't factor into your review on this application. What we have established in this appeal is that NCES met not 1, but 2 standards for meeting the capacity need requirement under the public benefit criteria. First, under the long-standing interpretation that was employed by DES until 2020, NCES established there was a capacity need for the Stage 6 facility because a shortfall would occur at some point in that 20-year planning period. And that was what we talked about when we first looked at the shortfall chart together, where under that interpretation, it didn't matter when the facility would be providing capacity, as long as that shortfall occurred in the planning period. That was the analysis DES utilized as recently as NCES Stage V application back in 2014. That reflects the plain language of the statute, and it's consistent with how the department reviewed applications for many years. But we told you how DES changed its interpretation with the Stage 6 application, and the witnesses explained what they were looking for when they reviewed this capacity need requirement with NCES's application. With the new application that NCES submitted, DES was looking for capacity after that shortfall crossover on the chart, and NCES did that. Stage 6 provides a year of capacity in a period when the state would otherwise be in a shortfall and have not enough landfill capacity and permitted capacity for the waste generated in this state. That standard is far stricter
but 2 standards for providing capacity need under the statute. How much capacity will be provided is irrelevant, because again, the legislature eliminated the guesswork when it said, quote, in order to determine the state's solid waste capacity need in RSA 149.11.5. It then prescribed those 4 steps that must be followed. CLF may want to talk about short and long-term need. It is abstract concepts, but it cannot ignore the clear language used by the legislature and the instructions it provided to guide the department in that analysis to determine whether the need exists. And each of those instructions was followed here. So because DES carried out that analysis, it satisfied the criteria in section 5 of 149 and 11, which means the short and long-term need does exist. The next thing the department considered was the second element of our analysis, which is the hierarchy and goals element. CLF's argument that the permit is somehow erroneous because landfilling is last on that hierarchy is unsupportable. The plain language of the statute says that the methods on that hierarchy are endorsed in a particular order. And that means each method bears a stamp of approval by the legislature. The obvious reason is that some things can't be handled by diversion or other waste management solutions. Some things can't be recycled, some things can't be composted, and they need to have a destination. It is impossible, given the nature of some items in the waste stream in New Hampshire, to eliminate landfills entirely. And you heard all of the witnesses confirm that landfills are the catch-all for these kinds of waste to ensure that they have a destination. And no one, not even Mr. Durfer, testified that least favorable means cannot be approved. Now, much of CLF's appeal turns on the permit conditions set forth in Condition 27. And you've heard the witnesses and the attorneys talk to you about the Condition 27 and NCES's permit, and Condition 21 and the turnkey permit, which several of you were, I believe, sitting here to deliberate three or 4 years ago when that hearing proceeded in front of this very council. That condition says the public benefit will exist when the condition is satisfied. But Mr. Durfer lamented that this condition and the department have not defined how diversion should be calculated, and that this somehow invalidates the permit, the entire permit itself. This is an example, though, of what I told you on Friday, where the Supreme Court has done the work for you. At the end of its order looking at the turnkey permit condition, which all of the witnesses agreed are substantively similar in terms of what they require the permittees to do and report to the department, the New Hampshire Supreme Court said it's problematic that there's not a definition for diversion, but it said that after affirming the council and concluding that it was not unreasonable to include that condition in the permit in the first place. Now, I told you on Friday, too, that the heavy lifting has been done for you, and I want to give you a few specifics on that. And I'm going to read you a couple short sections from the Supreme Court's order that tell you exactly why this condition is reasonable. The court said, quote, regardless of how the diversion rate is calculated under Condition 21, the permit will assist the state in achieving its waste diversion goal and disposal hierarchy by providing DES crucial information about the composition of the waste stream, in particular whether and how diversion is being achieved through source reduction, recycling, reuse, and composting, and it cites the statute, informing the development and implementation of future diversion strategies, end quote. The court goes on to say, quote, the condition's requirement that waste management work with 15 or more waste generators further supports the conclusion that the permit assists the state's efforts to achieve its waste reduction goals and hierarchy, irrespective of which generators collaborate with waste management, end quote. And finally, the court said, requiring waste management to collaborate with waste generators to improve their diversion methods and decrease the amount of waste they generate and contribute to the turnkey landfill will decrease the amount of waste that's ultimately landfilled, and accordingly, Condition 21 will assist the state in achieving its waste diversion goals and disposal hierarchy. That's why it's reasonable for this condition to be an NCES's permit. The Supreme Court has told you why it's reasonable and why it will advance the very goals that are at issue in the public benefit determination. NCES's permit contains the same condition with the same requirements for reporting and collaboration. So here, your work has been done for you. The Supreme Court found no error requiring remand in the turnkey appeal, and you should reach the same conclusion in this matter. Now finally, CLF claims that the permit can't be lawful when it was issued utilizing the 2003 solid waste plan. And again, this is something that's probably quite familiar to you because the same argument was raised in the turnkey appeal back in 2018. DES used the same plan in reaching that decision, and again, the council found the argument was CLF has not pointed to anything in the law that establishes it was unlawful to issue a permit utilizing the 2003 plan. In fact, Mr. Wimsatt explained to you that the state solid waste plan has to be utilized in making permitting decisions, and so the department had no choice but to use the plan that is available to it. Both Mr. Wimsatt and Mr. Durfer also told you that the goals in this plan are still good goals. The document may be out of date, but the goals are still worth pursuing. And if you'll look through NCES's detailed submission, which is one of the NCES's exhibits, you will see that the applicant addressed each of those goals in its application to demonstrate why this facility will advance those goals and assist the state in meeting its objectives. There is no penalty to the department for not having an updated plan. While the legislature required DES to adopt a new plan, it did not provide a penalty or any kind of repercussion stating that the department cannot issue permits if it doesn't update the plan. And a lack of an updated plan is not due to disregard or neglect, ignoring what the law requires. The DES witnesses told you that there are financial and staffing constraints that prevented the department from doing this work. And Mr. Durfer explained that the work to be done updating the plan is extensive. It's not updating a Word document with a few changes here and there. It is an overhaul of the plan that requires time, expertise, and attention. These are issues that predate this appeal, this permit, and even the current Director of Waste Management. But the 2003 plan, it's important to keep in mind, is just one tool the department has in its hand when it's reviewing applications. All the witnesses told you that DES stays on top of current trends and developments in the waste management industry. They have conversations with the regulated community. They're engaging with the public. They're talking with their peers in other states. The department is not locked into a box from 2003 when it's reviewing an application. And that's why it's reasonable and lawful for that one component, that one solid waste plan, to be a piece of the broader picture that the department considered when it reached this decision. That's why the decision is lawful. That's why the decision is reasonable. As you begin your deliberations today, I encourage you to think about all that you've seen and heard in this hearing, because you've been given a glimpse behind the curtain to see the hard work that goes into the complex permits that are issued for these facilities that keep our solid waste system going. You've heard about the detailed submittals provided by the permittee and the hours of time spent by the department reviewing, analyzing, calculating, and evaluating that application before reaching a decision. The department would not have issued this permit if there was not a good reason to do so, and they've given you all of those reasons in the documents before you. CLF can't point to any actual error that justifies a remand of this decision, and it's taken up enough of your time in furtherance of its objectives. You should feel very confident in denying each element of CLF's appeal. And again, we thank you for your time.
Great, thank you, Council. Okay.
Good morning. Thank you for your time on Friday and today dedicated to this appeal. Conservation Law Foundation has failed to meet its burden to prove by preponderance of the evidence that the department acted unlawfully or unreasonably in issuing this permit. With respect to the capacity analysis, we heard from the department panel just how much effort and work goes into the N11.5 capacity calculation and how many factors are evaluated with respect to the short and long-term need analysis of N11.3A. The department evaluated these factors and implemented the analysis to find a public need for this facility. With regard to the lawfulness, I once again refer to the pre-hearing memo. It is about the full analysis that is performed, taking into account all factors. Factors include the geography, the type, and proposed location of the facility. With respect to RSA 149 M11B and Condition 27, the department next testified that the permit assists the state hierarchy and goals of M2 and M3. Landfilling, while least preferred, is still part of that hierarchy. Condition 27 does a lot of work in terms of ensuring that the permit provides the assistance required by M11.3B. Condition 27 requires NCES to work with its generators and provide DES data that it doesn't otherwise have access to, which will in turn better inform the department's future permitting efforts and planning efforts. The condition also requires NCES to work with specific generators and municipalities to assist them and improve their solid waste practices so as to further assist the hierarchy of diversion goals. The department said it would work with the permittees to refine the condition over time. CLF has not demonstrated any evidence to suggest that the department is under some binding obligation to refine this permit condition prior to using it in another permit. Instead, consistent with what the department told this council during the turnkey hearing, the condition will be a tool to receive data that it doesn't otherwise have access to. The Supreme Court upheld the council's determinations in the turnkey hearing on this basis when it ruled that the council had sufficient evidence before it to uphold that condition. That same evidence is now before the council today in this appeal. The department has not yet received a Condition 21 or 27 report from either Waste Management New Hampshire or NCES, and when it does, as the department testified, the data it receives may only need to be reconfigured, but all that data will be there for the department's use. The condition, therefore, serves a tremendous public benefit and serves the hierarchy and goals of M2 and M3. These conditions are new, have not yet been put into practice by Waste Management or NCES through a filing of a report, and must remain flexible to ensure that they are properly implemented. With respect to the state plan and M11.3C, CLF has failed to meet its burden to demonstrate that the department's use of the state plan was unlawful or unreasonable. CLF has not demonstrated that there is anything that renders the current state plan invalid or that it expired at any point. Instead, as the department testified, the 2003 state plan is the state plan and is what the department must use for permitting. You also heard from Mr. Durford, who told you that many of the goals of the state plan are still quite valid today, and further told you that he believes the department are dedicated, hardworking staff, and that they are very well informed on the advancements and issues related to solid waste management. The department too testified that many of the goals of the state plan are valid today, such that reliance upon that state plan for permitting is okay while that new plan is under development. Once again, your role as the Waste Management Council is to decide issues of fact in this appeal and determine whether CLF has met its burden of proof. The question is whether CLF met this burden to show that the department was unlawful or unreasonable, not whether the department could have or should have done something differently. There are many ways to make a permitting decision, but it was CLF's job to demonstrate that the one the department made was the wrong one. Here, the department evaluated all facts and circumstances, implemented the public benefit analysis, and took the concerns of the public into consideration in rendering its decision. We ask that the council deny CLF's appeal and find that it has failed to demonstrate that the department acted unlawfully or unreasonably. Thank you.
Very good. Thank you, Council.
I have handouts for the council. Can I approach the council members and hand them out and pass them around?
What are these handouts?
Sure, this is a visual. If we had a projector, this is what I would put up in the display.
Okay, I'll make sure turn it around. I'm just working before you hand back. Deal with this real quick. And Attorney Harrison, you had a chance to.
They haven't seen it yet, but I have it for them now. This is a summary of our arguments. It's just a visual. Like I said, if we had a PowerPoint, or if we had the ability to project it up, I would put this up on the screen, and it just summarizes our closing. So it's meant to be a helpful tool for the council, and it actually goes point by point, answering the questions that the council asked us beforehand. So it lays out each condition and describes why they are unlawful and unreasonable. So I think it will be pretty helpful for the council.
Attorney Harrison, any objective issues? I think, as a visual aid, I think this is entirely fine. I don't see anything here that's raising concern for me.
Yes, I think as a visual, it's fine, just not marked into evidence or treated as an exhibit or anything like that.
Of course.
I think that's okay, as long as it's a visual, maybe not call forward into the deliberations, they would go away for a long objection.
Yep, that works for me. So,
No, I mean, I would ask if the council's taking the questions back with them, and they are allowed to take their notes, that they take the handouts back with them in deliberations. I think it will be very helpful. And it's, I think it's standard practice in closing arguments that handouts are often used.
I would object only to the extent that, as Attorney DeMarco said, this would normally be something on a PowerPoint to help the council follow along. So I think they could take notes on what they'd like, but I don't think this is kind of extra material for the council to have on hand during those deliberations.
As I said, it goes through item by item. It responds to the questions as the council asks, and I did describe it as a PowerPoint, but it is also common practice for handouts to be used. We've talked a lot about the turnkey hearing, and I do know that this is the practice that was used by the committee. In that turnkey hearing, they did provide a handout on those 3 criteria. And the evidence showed on Friday that DES's permitting decision on those 3 criteria is both unlawful and unreasonable. And I've laid that out here in the handout, which hopefully will take you through this and also respond directly to the questions that we received from the council this morning. So the first criteria is the capacity need. And as you heard, DES must determine that the landfill addresses both a short-term and a long-term capacity need. And it must make both of those findings. It cannot be short-term or long-term. It must find both. And let's look at how that analysis is made. You heard from counsel from NCES that DES makes an analysis of shortfall over the next 20 years from provision 5, RSA 149 M11.5. And that is the first part of the analysis. They do the calculation under 5, but then DES must determine if there is a shortfall, if the permit addresses a short and long-term capacity shortfall. And that is not just my interpretation of the statute. That is the council's interpretation of the statute. In this council's November order on the motion for reconsideration, the council said there are, quote, 2 independent determinations that DES must make. First, DES must determine if there is capacity need pursuant to RSA 149 and 11.5. And then DES must determine whether a proposed facility satisfies the calculated capacity need under the A criteria for substantial public benefit. DES is explicitly charged with considering both the short and long-term need for the proposed facility based on the calculated capacity need. And counsel for the state agreed in the pre-hearing brief in this memo. They said, quote, with respect to the capacity need analysis, the department agrees with the interpretation of the hearing officer in his November 19th order, and went on to say that first, DES must find there's capacity shortfall under provision 5, and then must consider both the short and long-term need for the facility. Let's look at DES's capacity calculation. DES's capacity finding is unlawful because they simply did not make a finding of short and long-term capacity need. You heard from DES on Friday, and the record is clear. Their analysis is in Exhibit 8, the application review summary, and you can see it in the permit and the response to public comments, Exhibit 7 and 9. They did not find that there was a short and long-term need, or that the permit will address either short or long-term need. They didn't find that there was that the permit addressed a short-term need, and that makes sense because for the first 5 years that the permit will operate, it operates during a time of excess capacity. So there is no short-term need. And they didn't find there to be a long-term need because that also makes sense. They found that for 1 year in 2026, there will be a need for the facility. DES found that the permit satisfies a 1-year need, and that is not the standard. When questioned by the council on Friday about this, DES said, quote, we have not parsed out where in the 20-year period the break point is for short and long-term need. And the council asked them further, where is that, was there a short and long-term need? And DES said they have no rule of thumb, no convention for determining what the short and long-term need is. They were asked if 5 years is enough for long-term need, and DES said, no, they're not saying, they're not going to attach a number to that. So DES has failed to make this finding as they require their statute, and their determination here is unlawful. It's also unreasonable. And it's unreasonable to make this capacity determination because, as you heard on Friday, for the majority of the time, 5 out of 6 years, the permit will operate during a time of excess landfill capacity. And New Hampshire does not benefit from landfill capacity that we don't need. You heard testimony from Mr. Durfor, the former executive director of the Northeast Resource Recovery Association. There is no public benefit from excess landfill capacity. The public is harmed by the landfilling it gets filled with out-of-state waste and waste that could otherwise be recycled. And DES also testified to this on Friday, that excess landfill capacity is usually filled with out-of-state waste. When asked about this, the DES panel said on Friday that New Hampshire does not benefit from redundant capacity. DES explained, quote, when you have significant excess capacity, you run into problems with the hierarchy. When you have so much excess capacity, it undermines the hierarchy. determination was further unreasonable because, as they explained, and this is in Exhibit 8, their analysis was conservative, and they may have overestimated the need. There might be no need in 2026. The Mount Carberry permit expansion was pending before DES at the time. And if Mount Carberry is permitted, we might have no need in 2026. DES could have denied the permit application and told NCES to come back in several years. Or they could have said that they don't get to start operating immediately. They could have allowed NCES to begin operating in 2026, but they didn't do so. They permitted 5 years of unnecessary landfilling. And finally, it's unreasonable because, as you heard, the landfill conveys a private benefit to a landfill company. DES testified that the obvious benefit of the landfill is the profits of the landfill company. And you heard that there were 2 permit applications for the for the Stage 6 expansion permit. And in the first Stage 6 expansion permit, NCES submitted the application to operate it for 2.3 years, or until 2023. DES told them there was no public benefit. NCES withdrew that application and resubmitted it. And the only change between the first application and the second application, and DES testified to this, that the only real change between the two is that NCES slowed down the fill rate to expand into 2026. And they only did this so that they could get a permit. And that slowed down fill rate and longer operation period doesn't benefit the public. It benefits NCES and their business operations. And as you heard the testimony on Friday, it serves as a bridge between the current landfill operations in Bethlehem and the proposed new landfill in Dalton. And so there is no public benefit, and the capacity determination by DES is both unlawful and unreasonable. As to the second category, the hierarchy and goals, this is on the second page of your handout. As you heard on Friday, to address this criteria, DES relied on the public benefit condition, condition 27. And that condition is incredibly vague and ambiguous. And the ambiguity renders the condition unenforceable. And it is unlawful for DES to rely on an undefined permit condition to satisfy statutorily required criteria. It's unlawful for the public benefit determination to rest on a condition where DES doesn't know what the terms mean, doesn't know what the effects will be, and doesn't know how to enforce that permit condition. And it's unlawful for DES to shift the defining of those terms to the permittee, for DES to write a condition and hand it to Casella and say, let's see what you do with it, and let's see how Casella interprets this. It is DES's job to write the permit conditions, and it is unlawful for DES to hand that role over to the permittee. It is also unreasonable for DES to do so. And now you heard from NCES's counsel about the turnkey decision, and it is important that this counsel understands that you are not bound by that turnkey decision or by the New Hampshire Supreme Court upholding that 3-3 vote of the Waste Management Council. And on Friday, the council took judicial notice of the fact that council members in turnkey expressed concern over the vagueness and ambiguity of this condition, and that in turnkey the council issued an order noting that the condition was vague and ambiguous, but voted to uphold it only on the understanding that DES would refine the condition. And in this matter, this council's order from September 2nd, 2021, this was explained by the hearing officer, saying, quote, the mandates of permit condition 27 are similar to those the appellant and the council considered to be vague and ambiguous in condition 21 in the prior turnkey permit appeal. It is important to note that the council also observed that DES obligated itself to continue to work with Waste Management New Hampshire staff to clarify these vague and ambiguous requirements, including coming to an agreed definition of diversion for condition 21 to be enforceable. And the New Hampshire Supreme Court noted this as well. In their conclusion, they say, we offer one observation in conclusion. Neither the legislature by statute nor DES by rulemaking has defined how diversion rates should be calculated. The lack of a statewide definition makes it problematic, even with robust data, to determine where the state stands with regards to 40% encourage the legislature or DS to establish a method by which diversion rates will be calculated. And that was the expectation. After turnkey, the DES was going to refine these conditions. And the council phrased this question here for this, in the September order for you today. The hearing officer framed the issue this way. The turnkey permit was issued on June 11, 2018. The subject permit was issued on October 9, 2020. DES has had roughly 2.5 years during which to refine the terms of condition 27, including the definition of diversion, and presumably has done so. The subject permit nevertheless fails to reflect any of these refinements. The issue before the council now is whether these refinements have been made, and if so, what are they, and whether they advance or hinder the achievement of the state solid waste reduction goal within the meaning of the statute. And so that's the question for you today. Have those refinements been made? Has DES done anything to further refine these conditions? And the answer is no. You heard that testimony on Friday. DES has not done anything to refine them. They're using the same permit conditions again. And indeed, they testified that they still don't know what the conditions mean in turnkey. They're waiting to see what happens in the turnkey conditions. You heard Mr. Durford testify that the terms are vague and it's unreasonable for DES to rely on them. And when you deliberate, I encourage you to look at Exhibit 7 and look at those permit conditions and see where the terms are undefined. 27C, how much disposal capacity must they reserve for New Hampshire waste? It doesn't say. How is the diversion rate calculated? What counts for diversion? Does alternative daily cover count for diversion? When asked about if alternative daily cover counts for diversion, you heard DES testify on Friday that they don't know. And they actually said, quote, they will be very curious to see what our permittees do with that issue. The terms are undefined also in 27D. There's no, NCES gets to determine, according to the condition, if it's making the 30% diversion rate. And if it does, there's no deadline for reporting that to the council. Under 27E, there's no criteria for selecting the waste providers, the waste generators that they are to work with. DES said on Friday that they hope it will generate assistance to 25 communities, but the permit only requires them to assist 5. And there's no guidance what that assistance means. What does it mean to provide assistance to undescribed waste generators, and who are they? And the council asked on Friday, does the condition have any teeth? And I think that begs the question, how will the condition be enforced if DES doesn't understand what the terms mean? Instead of writing permit conditions that DES hopes NCES will do the right thing with, DES should write strong permit conditions that require NCES to provide a substantial public benefit. It's unreasonable for DES to put these permit conditions out there and sit back and wait and see what the permittee does with them. And so DES's reliance on condition 27 is both unlawful and unreasonable. And finally, compliance, or advancing the goals of the state solid waste plan. This is on your 3rd page, and this is our final condition. DES's issuance of permits relying on that grossly outdated state plan is unlawful. DES is in clear violation of a statutory requirement that it update the plan every 6 years. And DES must read that statute as a whole, and the council, this is the rules of statutory interpretation. We read the statute as a whole to avoid absurd results. The legislature clearly intended planning to have a significant role in our waste management system. They mandated this every 6-year update, not as an academic exercise, but because they wanted to require DES to engage in planning first and landfill permitting second. And the permit is supposed to advance the goals of that plan. And they go hand in hand. Instead, you heard testimony from DES on Friday that DES is choosing which statutory provisions to comply with and which not to. They're complying with the landfill permitting and not the planning requirements, and that is unlawful. stated their priorities. They said with limited budgetary concerns, they are prioritizing landfill permitting and permit compliance over planning. The legislature has said what the hierarchy is, and it is not up to DES to invert that hierarchy. And finally, it is unreasonable for DES to rely on the 2003 state plan. It is inherently unreasonable to rely on data and planning from 2003 to issue landfill permits in 2020. The plan is grossly outdated. DES's budgetary concerns are no excuse. DES testified on Friday that when they want to get something done, they do that. They find the resources for it, and they've decided that that is landfill permitting. They've put that as their priority. You heard Mr. Durford testify that there are many things the plan could and should do to provide solutions in the state. And while the goals of the plan remain valid, no progress has been made on critical issues. DES testified that there's many things they could be doing, including planning and in the plan, that don't require legislative action, that just DES can do. And so, as the evidence is clear, DES's determination regarding using the state solid waste plan to issue landfill permits was both unlawful and unreasonable. And as you heard on Friday, CLF sued DES for their failure to update the state plan and continuing to issue landfill permit after landfill permit relying on that 2003 state plan. And as you heard, the court dismissed the case. And when doing so, the court said, we're dismissing the case because I want you to take it to the Waste Management Council. It is the Waste Management Council's role to tell DES that it's unlawful and unreasonable to rely on this outdated state plan to issue solid waste permits. And that is why we're here today. It is the council's role, and it's not going to be the courts, and it's not going to be the legislature, to tell DES that the permit does not meet these three criteria. And so I'll ask you today to determine that the permit does not meet the three required criteria and is both unlawful